We've got Shannon Bream standing by. She's on the phone for us right now in what has been about a five-year conversation. The Supreme Court is now setting aside this court ruling, Shannon, against the baker who wouldn't make this wedding cake for that same-sex couple. What are you learning now that you've been able to look at the details here? The Supreme Court ruled 7-2 that Colorado's actions violated the free exercise clause.
Yeah, it's interesting. I haven't been able to read the whole thing. Unfortunately, I'm in my car on the way to the studio. But from what I can tell, we really thought they would be looking back to these statements by the commission, the initial first body that looked at this case and ruled against the baker here, Jack Phillips, because there were some comments by one of the commissioners that really called into question how he felt about this religious issue. And so it sounds like to me, in the wording of the opinion that I've seen so far, is that this is not a huge, broad, sweeping decision saying that no one ever has to participate in a wedding ceremony, same-sex wedding ceremony, if they're in the stream of business. But it certainly points back to this commissioner and says, if there's obvious religious bias or animus against someone because of their religious beliefs, you can't base a decision on that. And during the arguments, Justice Kennedy was tough on both sides, but there was a very pointed moment where he was talking to the attorneys for the couple and said, you know, tolerance has to work both ways, and I'm very concerned by what I've seen in this case, that tolerance was not extended to Mr. Jack Phillips, the baker, because of his religious beliefs. And you didn't want to pin too much one way or the other on that statement when he made it during the arguments because, like I said, he was tough on both sides, and, you know, you never know if he's playing devil's advocate or trying to still make up his own mind. But that moment really stood out because it was clear he thought that this baker had not gotten a fair shake. It looks like in this decision today, he's pointing back to that language from the commissioner and saying, you know, you can make a decision on these issues, but you can't do it with bias.
And that is noted in the opinion. The opinion was written by Justice Kennedy. Shannon Bream is on the phone with us. Justice Ginsburg and Sotomayor dissented. But he writes in the opinion that the reason and motive for the baker's refusal were based on his sincere religious beliefs and convictions. But Shannon, the court's not deciding on the big issue in this case, whether a business can refuse to serve gay and lesbian couples. Justice Kennedy says in his majority opinion that the issue, quote, must await further elaboration. So what does that mean?
Yeah, and that's an interesting point because I do think he's very narrowly pointing to the language from that commissioner and saying it's clear this first body that made the decision had some bias against him. Now, that doesn't mean we can't relitigate this issue when it becomes maybe a more fleshed out case in the future and you don't have that obvious animus against him. But we've seen so many of these cases that deal with florists, with photographers, with others. And we thought over the years that some of them were right for the court. They didn't take one until this one, and now it's very specific, making the ruling pretty specific as well. But I think it's going to stand for a while because I think that while these kinds of conversations continue going on with the makeup of the court and waiting to see if Justice Kennedy retires, I think that LGBT advocates will be hesitant to bring another case with the makeup of the Supreme Court as it stands today.